Good morning, Vice President Fielder. Can you hear me?
Yes, I can. Good morning. Thank you.
Okay. Good morning, everybody. Today's date is Tuesday, July 11, 2023. This is the time and place for our regularly scheduled business meeting. We are in the Bollinger Room of the Montana Public Service Commission. I call this meeting to order. Would my colleagues join me in reciting the Pledge of Allegiance? Pledge allegiance to the flag. I would note for the record, the time is 9:31 a.m. I would also note for the record that Commissioner O'Donnell, Commissioner Pinocci, myself, and Commissioner Bukacek are in the Bollinger Room this morning, and Vice President Fielder is attending online. So we do have quorum this morning. Montana Public Service Commission welcomes public comment from any member of the public who would like to comment on any matter on today's agenda or any matter that's within the jurisdiction of the Public Service Commission. Are there any public commenters within the room? Anybody that would like to make public comment this morning in the room? Are you sure? All right. Are there any public commenters online? Seeing none, there are no public commenters this morning. All right. There are no changes to the agenda this morning, so let's roll right into our action items. We have two sets of minutes, I believe, to approve this morning. So I will move to approve the commission minutes for the week of June 26, 2023. Is there a second?
A second.
All right. My motion has been seconded. Discussion. Changes, revisions? Seeing none, all those in favor of my motion to approve the business meetings for the week of June 26, 2023 signify by saying aye.
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 All those opposed signify by saying no. Seeing no opposition, minutes for the week of June 26 are approved. And then we have a set of minutes, I believe, for the out of cycle meeting that was held on June 29, 2023. So I'll move to adopt the draft minutes for the out of cycle meeting of that date. Is there a second? Commissioner Pinocci has seconded. Discussion, changes, revisions to the draft meetings for the out of cycle meeting. Seeing none, all those in favor of my motion to approve the draft minutes for the out of cycle meeting on June 29th signify by saying aye.
Aye.
All those opposed signify by saying no. Seeing no opposition, the draft minutes for the out of cycle meeting are adopted. All right. Thank you, colleagues. All right, let's move into our work session items this morning. Work session item number 1 is docket 2023.02.018. This is a commission initiated matter. This is City Service Valcon show cause order. We're here to act on a notice of commission action, which is to dismiss the show cause order. Mr. Palco.
Thank you, President Brown. Good morning, commissioners. As mentioned, this docket is 2023.02.018 concerning City Service Valcon. Just give you a brief background to remind you of what's happened in this docket. Originally in February of this year, the commission issued an order to show cause, identifying several deficiencies of City Service Valcon's record keeping operations, maintenance practices, and procedures. Since then, we received responses from City Service Falcon, and we believed in April of 2023 that they had complied partially with some of the order to show cause. However, because they could not achieve one portion of the order to show cause until the end of July, there was a notice of commission action that held the order in abeyance until July 31st of 2023. Since that point, our regulatory staff has completed further inspections, which included reviewing the operator qualification program, as well as observing a retrofit to the propane tank, which was the activity that wasn't that City Service Falcon had requested to schedule in sometime during the summer. Essentially, what this order says is that our regulatory staff has confirmed that all of the issues that we identified in our original order to show cause have been completed to regulatory satisfaction, and thus there's no remaining issues in the order to show. We recommend that the order to show cause be dismissed. So staff recommends approving the draft notice of commission action as drafted and allowing for substantive changes or non-substantive changes as necessary. And if you have any questions, feel free.
All right, thank you, Mr. Palco. Mr. Tierney, anything to offer? Okay. Commissioner Bukacek,
I move that we approve the notice of commission action to dismiss the order regarding violations because City Service Falcon has brought themselves into compliance.
all right, is there a second?
I'll second that motion.
I heard Commissioner O'Donnell first. So okay, we'll accept Vice President Fielder's second. Okay, we have a motion and a second discussion.
I would like to make a comment, Mr. President.
Sure, go ahead, Vice President Fielder.
I just really appreciate the way this agency works with the utilities, especially the smaller ones, to try to help them resolve deficiencies and come into compliance. I think that we have a very good approach to working with these agencies or with these utilities, and I'm happy to see that staff was able to get this resolved without having to escalate it further. Thank you.
Commissioner Bukacek.
I just want to say excellently stated, Vice President Fielder.
Commissioner O'Donnell.
And I would like to also add to that and agree with that. And that having been on the commission for 6.5 years, I've not come across any instance where the commission has deviated from that practice of working cooperatively with any utility or any party. So thank you.
Additional discussion? Additional discussion? Seeing none, all those in favor of Commissioner Bukacek's motion signify by saying aye.
Aye.
All those opposed signify by saying no. Motion carries unanimously. All right, thank you, gents. Let's move to work session item number 2. This is docket 2023.04.033. Dale Robinson, we're here to act on Dale Robinson's complaint, and we're here to consider a draft order appointing a technical master. Mr. Palco.
Indeed, you are stuck with me again. So this docket does have a lengthy procedural history that I'd like to go through first as well, just to make you aware of where we are today and what we're acting on. So on February 6th, Dale Robinson filed a complaint against Northwestern concerning service tariff rule number 18, which concerns small generator facility interconnections. In the complaint, Mr. Robinson's believed it was unjust and the tariff is unjust and does not reflect current technology. He asked the commission to appoint a technical master. Northwestern has since, or let's see, the commission has determined that the complaint substantially complied with the requirements and ordered the directed Northwestern to satisfy the complaint or answer the complaint. Northwestern did in fact answer the complaint. From that point, which was May 17th, 2023, commission staff has been working with both Mr. Robinson and Northwestern concerning the appointment of the technical master. As detailed on pages 2 through 4 of this draft order, we had to contemplate the exact role of the technical master. According to case law, most often a technical master is to aid and assist the commission or the court in determining technical issues. However, our rules suggest that there's a more central role for the technical master. It suggests that the technical master is to resolve the disputes. So on page 3 through 4, we go through what commission staff recommends the role of the technical master to be. We're asking the technical master to review the evidence and arguments presented by the parties in support of their positions and eventually prepare a report to us and the parties as the technical master. If the parties agree to that recommendation in the report, then that will consider the docket completed. If the party disputes that, then the parties may request a hearing on the merits. Any party may then call the technical master as a witness and examine the technical master concerning his analysis and recommendations. So that's the role that we are considering for the technical master in this dispute. We came up with that because this is a not oft used provision of our rules. Concerning the selection of the technical master, as I mentioned, commission staff had been working with the parties. Commission staff asked both Northwestern and Mr. Dale Robinson to provide a recommendation of a technical master who they believed would be able to resolve or to be in this role and resolve this dispute. Northwestern recommended Dr. Matt Donnelly. He's a professional engineer from Helena. He holds a master's degree and a doctorate degree in electrical engineering. Mr. Robinson recommended Mr. Bill Brooks. He's a professional engineer from California. He holds a master's degree in mechanical engineering, and he's worked specifically in the solar industry for over 30 years. Most of Mr. Brooks' experience is with photovoltaic systems, which is in fact the main issue in the dispute here. Like I mentioned, commission staff then contacted each of them to discuss, the role of the technical master, the cost expectation or their hourly fee associated with their services, as well as their estimate of time commitment based on their experience. Dr. Donnelly gave us a cost estimate that was $215 per hour. However, he estimated approximately 100 to 120 hours to resolve the complaint. Mr. Brooks gave us a more expensive per hour rate. It was $300 per hour, but he believed he can perform his duties, I suppose, in 20 to 40 hours. So overall, Mr. Brooks came in at a lower cost. The cost is important in this issue. The cost is allocated between the parties by the technical master. That is one of the things that we are ordering the technical master to do upon the appointment, is to create a cost allocation between the parties in order for the parties to understand what responsibility or what financial responsibility they bear in this appointment as soon as possible. Ultimately, this draft order recommends appointing Mr. Brooks as the technical master. Mr. Brooks has extensive experience, as mentioned, specifically in the photovoltaic industry. We believe he would do this at a lower cost and in a more expeditious manner due to that experience. However, we do believe both Dr. Donnelly and Mr. Brooks are extraordinarily qualified to perform duties as the technical master. One thing I did want to bring to your attention that was brought to our attention recently is that there is potential that Mr. Brooks may not be able to practice engineering in Montana without a license. So far, it's brought to our attention that he may not have a license to practice engineering in Montana. However, after reviewing the licensing statutes in Montana, it seems like there's a pretty easy process to obtain a license through comedy. And so we're attempting to work with Mr. Brooks in order to gauge how long it would take him to obtain a license in order to make sure he's able to, in fact, practice engineering in the state of Montana. Staff believes editing the order to ensure licensure is important because we don't want to put Mr. Brooks in a difficult position. Commission staff seeks to make edits to the order to create a reasonable timeline for Mr. Brooks to create or to obtain a license to practice engineering in Montana. It was not included in the draft order because I still have not been able to contact Mr. Brooks to discuss this matter to ensure what a reasonable timeline may look like. Commission staff also seeks to make edits to this order to appoint Dr. Donnelly if the timeline or if Mr. Brooks does not comply with the timeline set forth in the order. If he does not comply with that timeline set forth in the order to obtain licensure. So ultimately, staff recommends approving the order and allowing for the staff to make the identified substantive changes concerning the licensure and licensure timeline and make any other non-substantive changes as necessary for clarity. There might be plenty of questions, but I yield.
Commissioner Bukacek.
I move to appoint Dr. Matthew Donnelly as technical master.
Okay. So all right. I'll second that motion for purposes of discussion. Commissioner Bukacek.
So it's going to take me a few minutes to explain why I recommend Dr. Donnelly. So with your indulgence, Mr. President.
Yes, of course.
Okay, thank you. So it's not as simple as just a technical matter. And I think that looking at the desired relief by Dale Robinson and by Northwestern Energy highlights that. So here's a summary of desired relief by Dale Robinson. Number one, technical master to examine the need for an external lockable visible load break disconnect switch. Mr. Robinson stating such a system is redundant when a circuit breaker will suffice to protect workers. Number two, from Dale Robinson, technical and tariff changing request that the language of electrical tariff rule 18 section 6 be modified so that all small scale PV systems comprised of UL 1741 and IEEE 1547 compliant components be exempt from the external disconnect switch requirement and allow NEC required circuit breakers to serve the purpose of providing a means to connect for the utility. So that's kind of how I summarize the desired relief of Dale Robinson. The desired relief for Northwestern Energy. Number one, make a legal determination that Northwestern has complied with all applicable laws, statutes, rules, regulations, and tariffs, and has not violated these in dealings with Mr. Robinson. Number two, to make a legal determination that Northwestern is required under tariff rule number 18, section 6, to require the installation of an external lockable visible load break disconnect switch accessible by Northwestern. So if this were earlier in the process, I would have made a motion to dismiss this complaint outright, because the more I read about this particular issue of contention, the rationale for this device, the more I see that it's actually subject to debate. It is not clear. It's not settled technological science by any stretch of imagination. And those who promote the use of these devices, they consider them important for the safety of workers in the field. So the formal complaint by Mr. Robinson is clear and concise, and he provided a copy of the referenced article on page 2 of his complaint. It's an article in the Department of Energy's National Renewable Energy Laboratory dated January 2008. So that was 15 and a half years ago. And it talks about evolving technology and standards and changing perceptions. The article was generally unfavorable to the utility accessible EDS, but it used a lot of subjective terms and said that its requirement, quote, has been an issue of debate among utilities, state PUCs, and PV system integrators and installers for several decades, end of quote. So debate means it's not settled, and that is using the complainant's reference. So I could not find any updates that settled this debate. Because we are this far in the process, dismissing the complaint is not an option. Mr. Robinson filed just over 5 months ago, and he stated in his February 6, 2023 formal complaint that his timeline to complete this project is late summer 2023. Looking at the options of Mr. William Brooks or Matthew Donnelly as technical master, Mr. Brooks is not licensed in Montana, as we talked about, as a mechanical engineer. And while he has an impressive resume, it is all related to PV industry technology, and his work has been in California for the last 25 years. And again, this issue before us is not subtle technological science, and the desired relief of both parties is beyond technical expertise. Mr. Donnelly's education is more broad, including a master's in business and a PhD in electrical engineering. He has experience in energy research and development, electric power system dynamics, transmission, renewable energy, and emerging forms of energy generation and storage. And the more hours that he's requiring, I think, is because he would be more capable of taking into consideration all the different complexities of this, because it is not just a technical issue. So since the technical issue remains debatable, I recommend the technical master with more broad experience, capable of a more broad perspective, and that would be Dr. Donnelly.
Okay, so just to clarify, Commissioner Bukacek, your motion would be to have the commission appoint Mr. Donnelly instead of Mr. Brooks as the technical master.
That is
Right.
correct.
Okay, Commissioner O'Donnell.
Thank you. Question. I guess it's a technical thing, but why would anybody, in order to be render a decision on this, why would somebody need to be a licensed engineer in the state? They're not doing anything. They're not practicing anything. They're just giving an opinion.
We wanted to take the time to confirm that with Mr. Brooks. There's a pretty broad definition of practicing engineering in Montana based in some of the licensure statutes in Title 37. So we wanted to just dot our I's and cross our T's to make sure either he had an explanation saying why it shouldn't be considered practicing engineering, or ensure that he is in fact practicing engineering, is licensed to do so in Montana before the formal appointment.
So what you're saying
That's
is
why
that, it would be a requirement that somebody be licensed. I find that to be odd, but if that's the law, that's the law. But as I recall in previous hearings, when this came up, it was a contentious issue of whether or not that, what's it called?
the external switches
are necessary or not. And I forget his opinion, but I remember the intensity of the opinion of the union representative, who said that his people would absolutely refuse to work on a system that either had or did not have. I forget what the situation was. And so that becomes a practical matter of whatever the law says, whether or not there's somebody capable of doing it or willing to do it was an entirely different matter. I also, the estimate of 100 hours, I cannot even conceive of how this would take 100 hours. All the information is out there. It would just be collecting information that's readily available, and testimony seems to be exorbitant to me. Even though 100 hours sounds like a lot, but it's just 2.5 weeks of one person full time. I can't even imagine that. But I think that a decision could be made relatively easily. It will not satisfy the other party. There's no way of reaching any consensus or compromise on the whole thing. It's either A or B. And so what this would do would be to decide A or B, and whether or not the legislation on the state would conform to any decision that we make is entirely questionable. Anything to do is questionable. So we simply don't know. So we're it seems to me, in a tough situation right here. And I sort of agree that we shouldn't be involved in this at all because anything that we do won't resolve the issue. So, Mr. President.
President?
Hold on. Mr. Belko, did you want to
Yeah,
respond?
one thing I would mention is, the reason we do have the technical master in this process is because we, as the commission, we may not have the expertise in these areas of really technical engineering, and electrical engineering in particular, that does affect, the utilities. We have previously determined that the complaint substantially complied with the commission's procedural rules. So at this point, we still are in between a hard place. We, as mentioned in our order, we have tried to work with the parties to see if there was ever an agreement between the two parties, both before before contacting the parties. We wanted to see if they both would agree on a single individual. After contacting the parties, we sent out the same information that's in this order concerning the costs and the time. There was still no agreement. So I agree it is a difficult place to appoint. However, I will say from staff's view and my view from contacting these individuals, both are extremely qualified to serve as a technical master in this issue. That's why when mentioning the licensure issue, we are confident that if our primary recommendation of Mr. Brooks is unable to become licensed, or the timeline to become licensed is too long to be appointed, be in this role as technical master, to have some kind of expeditious determination on this issue, that we are confident Dr. Donnelly would also serve well. To address Commissioner Bukachuk's point about the timeline and your point about the timeline, in conversations with these individuals, we feel like the timelines, or the quoted time by each of the parties, the quoted time by each of the technical masters, Mr. Brooks was much shorter because staff believes that he has a significantly more in-depth background with concern to PVs and PV interconnections. He has worked on rules across the country, has worked with utilities across the country. He's worked with, in fact, Northwestern back in, I want to say, the early 2000s, and it's been disclosed to both parties. So we believe that his time commitment was a result of his industry expertise, specifically surrounding this issue, comparatively to Dr. Donnelly's general expertise, and he certainly does have very qualified general expertise, and he would do a great job. We just believe that might have been the cause of the discrepancy between the two issues as represented to myself in conversations with both of these technical masters.
Commissioner Bukachuk.
With respect, I disagree with Commissioner O'Donnell that this is an easy matter. If it was just a technical issue, that would be one thing. But if you look at number 2 of the desired relief by Dale Robinson, what he is requesting is that the language of Tariff Rule 18 be modified so that all small scale PV systems comprised of these certain UL 1741 and IEEE 51547 compliant components be exempt from using that external disconnect switch. And that union representative, my recollection, because the people that support using this EDS, it's a safety issue for the workers. So my recollection is that union representative wanted this for their safety. That's my recollection. So it's not a simple matter. It's not just a technical matter.
Mr. President.
Commissioner O'Donnell.
Thank you for the clarification on that. And I recall that was the position of the union representative in terms of safety. So it struck me at the time in the conversation that the desire to not have that requirement on there was simply preferential, basically having to do with the cost of the system. And if we're having that external switch was adding to the cost of a PV system and was redundant on the whole thing. The reason why I say it's simple is that the two sides are clearly defined, very, very clearly defined. And I don't see any way that there can be any compromises. I understand the issue, but that would be for a technical master to determine something like that. but it seems to me there is a requirement or there ain't. One or the other. There can't be a midway type of thing. They might be able to come up with something to say, well, certain ones to be exempt or grandfathered or this thing or that thing, whatever type of thing. But that's very, very murky, and that is beyond our abilities. But as I say, it just seems to be preferential to me. The PV people are saying that the union people, their insistence upon the existence of that external switch for safety purposes is overblown and feather bedding on the half of the union's part. I don't see any room for any compromise on the whole thing except by edict, and that could certainly be changed. We're not the final authority on the whole thing. The legislature is. So that's the reason I think that it's redundant. I mean, it's silly for us to be involved.
All right, so I'm gonna step in here and just remind my colleagues that the purpose of today's decision is to make a determination as to a point to provide the information to us as to what they believe is the technically correct outcome for this matter. Again, I would remind each of my colleagues that ultimately the technical master doesn't make the final decision in this matter. We do. So we have a limited scope of decision today as to who to appoint as the technical master. So we don't need to be getting into the substance of argument, if you will. Okay. I'm not going to recognize you. I'm going to make my remarks at this point.
Sure.
Okay. I have a couple questions. Okay. So Mr. Palco, I appreciate your raising the questions of licensure for Mr. Brooks in Montana. I would say one of the deficiencies in the draft order was the fact that the draft order recognized that there was an issue as to whether or not Mr. Brooks needs to be licensed, and then it wasn't resolved in the draft order. So that in itself was, I thought, problematic. So any final order we issue on this needs to address that matter. I think one of the considerations here is costs. It's my understanding that you're averring that the technical master will assign who bears the costs of hiring the technical master. Is that correct?
That's correct. Subject to approval by the commission, but the technical master will propose those costs, the cost allocation between the parties, subject to our approval.
Is the PSC considered a party for purposes of assigning costs?
That issue has been brought up as we've read the statute. They're not. It's between the parties of the dispute or the parties of the complaint. It's in rule. Let me cite it for you. Montana Administrative Rule 38584133 is the rule. It doesn't explicitly say between the parties, but because it's to resolve the dispute between two parties to a complaint, the rule has been interpreted to be costs allocated between the parties subject to commission approval, because it would not make sense also for the commission to approve costs allocated to itself.
Okay, and then I do recall, which I think Commissioner Bukacek alluded to, that Mr. Robinson basically indicated that he felt that this was of some there was a time issue involved, and he wanted this complaint resolved, or this matter resolved sooner rather than later. Is that correct?
That's correct.
Okay, and at this point in time, we do not have an answer as to how long it would take Mr. Brooks to get licensed, correct?
That is correct. As mentioned, with editing this order, or making substantive changes to this order, we wanted to create some safeguards in terms of creating a timeline for Mr. Brooks to obtain licensure. After this came up, staff communicated with Mr. Brooks, Mr. Robinson himself, to see if that extra time for licensure would be an issue and would change his recommendation. It did not. So we're at this point, again, recommend adding some timelines in the order in order to make sure there's a reasonable time, but that's not too long from this order for him to obtain licensure so we can get this started. It is, in fact, it is indeed taken quite some time from the origin of his complaint to now to even get this technical master appointed. So we're trying to do this in an expeditious manner.
All right, colleagues. So with those questions being answered, I'm going to support Commissioner Bukacek's motion to have the agency appoint Mr. Donnelly as the technical master in this matter. As I think Mr. Polkow referenced several times in his comments to the commission, both of these gentlemen are highly qualified and can do the job. I think the concern I have in issuing an order from the commission giving Mr. Brooks a time certain for getting licensed in Montana is that it creates basically what's called a condition precedent under the law where something has to happen before our order essentially becomes effective. I don't like those kinds of orders. I think if we just issue an order appointing Mr. Donnelly, then issues resolved, and then we wait for the master's report. And I also think, given that the complainant in this matter, if you will, has averred that he would like to see this matter resolved sooner rather than later, creating any further delay in getting relief in this matter is not in the interest of either the complainant or public or frankly us. So I'm going to support this motion. Additional discussion, Commissioner O'Donnell?
Thank you. Dan, in your discussion on this, you indicated that whatever the decision, that one party or the other could dispute it. Okay, I think you could object to it.
Correct.
Okay. And that's what I see is happening. The two sides are very solidified on the whole thing. And to the president's reference to my comments, I wasn't clear when I said twice that we shouldn't be handling this thing. My position is that we should not be involved in it. They're in the wrong court, that we should not be appointing a special, master on this thing at all. We should withdraw from this complaint completely. That's
Additional discussion?
Yes, Mr. President.
Vice President Fielder?
This is just a logistical question. I agree with the motion and concept. There's quite a bit of information in this draft order, several pages before we get to the order itself, the order section itself. It seems like if we have the time that the body preceding the order should be revised to reflect this motion, or just stricken so that we just have the order, which is paragraphs 15 through 20, substituting in Mr. Donnelly's name for Mr. Brooks's name.
I'm not sure how to respond to that, Vice President Fielder. So, Mr. Balco, do you want to?
President Brown, Vice President Fielder, may I recommend that staff take the time to revise the order in order to reflect, if voted upon, take the time to revise the order before issuing the order in order to reflect the decision of the commission rather than simply changing the name in the order.
Yeah, I think that was probably understood as part of Commissioner Bukacek's motion. Additional discussion? Additional discussion? All right, seeing none, all those in favor of Commissioner Bukacek's motion to appoint Mr. Donnelly as the technical master in this proceeding, we'll do a roll call vote on this, I think. Vice President Fielder.
Aye.
Commissioner O'Donnell? I don't know if you heard that, he abstains. Commissioner Pinochi? Aye. Commissioner Bukacek?
Aye.
And then I'm an aye as well. And so the motion carries 4-0 0 with 1 abstention. Okay. All right. That, and seeing no further business to come before us, I'll just announce to the public that the next commission business meeting will be Tuesday, July 25th, not July 18th. NARUC will be happening in Texas, and several of us will be attending that. So there will be no business meeting July 18th. Our next business meeting will be July 25th. Seeing the time is now 10:10 a.m., seeing no further business to come before the commission, I will adjourn today's business meeting.